Venhola speaks about her work with the Community Legal Clinic in Ontario, Canada.
We have been working on, over the last 5 years, in this dedicated litigation department, discrimination against people with different abilities. And also, we have been addressing questions of equality in the welfare system, equality in the healthcare system, and in the education system as well. And the education system is a huge, huge piece which is vastly underserviced. I expect it is similar here, that equality in education is just something that has never been really looked at in terms of human rights perspective. We have what we say is gone through the back door and the front door at the same time in terms of rights. We have encouraged the government through negotiations, because we don't just go ahead and litigate. We have a strategy in place where we talk to the opposing party, which is generally the government, about what it is we're doing and why. And we usually do that prior to commencing the litigation. So we give them a heads up, say, here's the situation. We give them, it's like a mini factum. You just say, here's the situation, here's what we're prepared to do, here's how we're going to argue it. You know, there's nothing secretive about this. What do you want to do about it? What we're trying to do is we're trying to convince, in our public interest litigation at this point, we're trying to convince the government to read the law, to consider it, and to apply it, the human rights law, when they make their decisions. This is unheard of, and there's a lot of resistance to it. We've had to go to court to force them to do this.
Robert Garcia leads the Centre for Law and the Public Interest in Los Angeles. He explains how he works with public interest law and litigation.
Brown v. Board of Education abolished segregation in the United States in 1954, at least as to public elementary schools. But 50 years later, urban schools throughout the country, particularly in Los Angeles, where I live and work, are more segregated than before Brown. Brown versus Board of Education, I believe, is the paradigm example of using litigation to achieve social change, what some people on both sides of the Atlantic would dismiss as using law to achieve social engineering. But ultimately, what is law if not social engineering? Brown versus Board of Education was a triumph. It was a victory that needed to be won, but the struggle never ends. We still face many of the same issues today. And the lessons that we've learned in Los Angeles that we offer for your consideration are that litigation is not enough. We engage in creative, multidisciplinary strategies that include, first of all, having a collective vision that brings people together to define the kinds of community where they want to live and raise children. Second, coalition building, because it's not enough to work with just attorneys. We work with community-based organizations, civil rights groups, environmental groups, business leaders, the spiritual community, because of the values of saving the earth and saving the people. Third, the need for strategic media campaigns. Next, public policy and legal advocacy outside the courts, including engaging the community, what Mel Cousins has called community legal education, I believe, in his report that is forthcoming. Finally, as I say, we are litigators, but we try to engage our opponents to find common ground, and we will bring lawsuits when necessary within the context of a broader campaign. And I said finally, but I'm an attorney, I always have one more point as to the strategies. Central to each of those tactics is multidisciplinary research and analysis.
The need to support initiatives at community level and to build coalitions is a theme throughout many of the day's presentations, as demonstrated by Dave Ellis and Jerry White.
One of the things from my experience is that community groups, information groups, citizens information centres are often very much aware of the possibility of a legal solution to the problems that are coming into them. They're coming in, they're working on the ground, and they are aware of it, but they have very little idea exactly where to go. And as a number of speakers have mentioned, I think really important, the building of a coalition, of a grouping between the lawyers, the paralegals, and the groups working on the ground, so that there is a way in which the information can go from one to the other in as seamless a way as possible.
I was struck today, as I prepared for today's conference, about the role of conferences in the development of social action on the part of the legal profession. In 1968, a conference organised by law students on the role of legal education prompted David Byrne, who is present today, together with 3 of his colleagues, to establish the Free Legal Advice Centres. And that conference then had a major impact in the development of what we might call the NGO legal aid sector. I feel quite confident that today's conference is going to mark another quantum leap forward in the development of public interest law and in the development of an appropriate role for the legal profession in the face of social exclusion.
Private solicitor Kevin Brophy speaks about the ongoing need to raise lawyers' awareness around public interest law.
First thing I'd like to say is I think that every solicitor should be made to attend one of these conferences at least once a year, because certainly for me it reignites my enthusiasm, makes me think again about the reasons why I became a solicitor in the first place. And I think public interest litigation is something that very few solicitors get involved in. And I'm absolutely convinced that it's not because they don't care, it's because they don't know how to, and they don't have access to the type of information that they need. And I would hope that if a public interest organisation is set up, that situation will change.
Sketching the history of public interest litigation, Roger Smith discusses the development of this area in the United Kingdom.
But then the fourth wall, which is what I want really to put some weight on, is the attitude and the culture of lawyers. Because of these changes, because of the availability of legal aid, because of a relatively strong NGO sector, there are people and organisations abroad in the United Kingdom to whom test cases and litigation, public interest litigation, is their meat and drink. They want to do it. They're looking for it. You can go to the Child Poverty Action Group website and you get a list of the test cases they're actively seeking. And added to that, there have been reference to pro bono. I would discount any lawyer who talks about the altruistic justification for pro bono. Rubbish. But I would start to believe anybody who talks about the enlightened self-interest of lawyers in undertaking pro bono. I want to leave a sense of enthusiasm. I think the experience of the UK, England and Wales over the water is that public interest litigation test case strategy at the present time is a really viable and vibrant technique which can be used. It is one to which we owe a great debt to the Americans, but you can actually trace its use back in London, in the United Kingdom, back in fact to the Anti-Slavery Society in the late 18th century. Slavery was broken, at least domestically. It didn't stop the Brits sending slaves around the world, but it stopped slaves in the United Kingdom as a result of cases in the late early 1770s, where Scottish advocates, to their great credit, who are members of the movement, made what we would call third-party interventions, displaying, in the words of the court, a copiousness and variety of curious learning, ingenious reasoning, and acute argumentation. Now, number one, when I die, he displayed curious learning, ingenious reasoning, and acute argumentation chipped in on my gravestone. But two, if you are a lawyer with those 3 attributes, boy, is this good time to be alive, old or young. Thank you.
In the questions and answers section, Maura McCallion supports the use of the courts in vindicating rights.
I've just received a note saying, can you finish in 5 minutes? And there's no question mark at the end of that note either. So I'm going to ask Maura McCallion to make her brief contribution. And I'm sure there may be 1 or 2 others as well, so we'll come back to you on that. But Maura, if you don't mind, yeah.